welcome to what is the first of a series of 3 webinars this autumn organised by the 3PB Barristers Court of Protection team. My name is Mathew Gullick and I'm the head of the Public Law and Regulatory Law Group at 3PB Barristers, and I'll be chairing today's webinar, which will look at the Court of Protection from the particular perspective of the discipline of geriatrics. It is great to be able to welcome so many of you from all across the country and from a diverse range of professional backgrounds, including clinicians, lawyers in private practice, those working in social care, NHS trusts and local authorities, to what promises to be a very interesting and informative session. Given the multidisciplinary nature of practice in relation to matters dealt with by the Court of Protection, we have very deliberately tried to avoid giving a purely legal perspective. We hope that sharing knowledge and ideas in this series of webinars will promote collaboration in working and ultimately be for the benefit of patients and service users. The 2 further webinars are on Tuesday the 15th of October, again 1 hour starting at 12 o'clock, in a similar format to today, looking at the Court of Protection and psychiatry. And then on Tuesday the 12th of November, also 1 hour at 12 o'clock, which will be a health and welfare case law update. You can see more details about all of those, about each of those sessions, and register to attend either or both of them if you haven't already done so in the events and seminars section of our website at www.3pb.co.uk, and you see that address on the slides. And if you have any queries in relation to the next 2 sessions, then do email us at response@3pb.co.uk. The PowerPoint slides for today's webinar will be emailed to you following the conclusion of the talks. We hope they will be with you later on this afternoon. But if for any reason you haven't received the slides in the next couple of days and would like to have them, then please do get in touch. Now, turning to our speakers for today's webinar, they are Ben Wildblood and Jim Hirschmann. Ben Wildblood is a consultant geriatrician and physician at University Hospitals Bristol and Weston NHS Foundation Trust. His specialist areas are acute care for the older person and cardiology for the older person. Ben is a college tutor with the Royal College of Physicians and also works as an expert witness in geriatrics and in general medicine. We are delighted that he has agreed to share his knowledge and experience with us this morning. Jim Hirschmann is a barrister at 3PB Barristers. He acts for both families and public bodies and specialises in adult social care, child social care, education and family law. He advises and appears in a range of jurisdictions, including the Court of Protection, the Administrative Court and the Family Courts. Jim is also a committee member of the Court of Protection Bar Association. The agenda for today's session is firstly a very brief introduction to the Court of Protection delivered by Jim Hirschmann, particularly aimed at those who may not be familiar with its work. Secondly, Jim is going to look at some Court of Protection case law involving issues relating to geriatric medicine, in which geriatricians have been involved as expert witnesses. In the third section, Ben Wildblood will discuss the decisions that geriatricians commonly make in the best interests of patients, take us through 3 anonymised case studies, and provide some reflections on the challenges of practicing medicine in this specialism. The 2 presentations from Jim and from Ben are going to last around 20 minutes each. Finally, in the last section of today's webinar, there will be a question and answer session of around 10 to 15 minutes following their talks. If you do want to ask a question, then please do type it into the Q&A box on your screen as we go along. You don't need to wait until the conclusion of the talks before raising a question. The questions typed into that box will only be seen by the panelists, that's the Q&A box, not by everyone attending, and your name will not be read out with the question. I'm now going to hand over to Jim Hirschmann for his presentation. Jim.
Thank you very much, Matthew, and good afternoon, everybody. So to start off, I'm going to start with the Court of Protection basics. So for those of you who don't know much about the Court of Protection, it's a creature of statute created by the Mental Capacity Act 2005. And you can see there, section 45(1), setting up the declaration by which it was created. I'm not going to read out the slides in full. They will be circulated, but there's some additional information there for further reading for those who are interested. So what can the Court of Protection do? It has very broad powers. I'm going to focus on two elements of those on this slide. Section 15 of the Mental Capacity Act 2005 grants the Court of Protection the power to make declarations as to whether or not someone has capacity. It also empowers the court to make declarations as to the lawfulness of an act done towards such a person. So if there's uncertainty about capacity, or if there's uncertainty about the lawfulness of an act involving someone without capacity, Section 15 is the anchor by which the Court of Protection can become involved. Section 16 grants the Court of Protection the power to make a decision on an incapacitated person's behalf, or to appoint a deputy who may do so in day-to-day matters. A third option I want to flag, because it's an important part of the background, is lasting powers of attorney. A lasting power of attorney is usually made when someone has capacity and then is registered when the person lacks capacity. The Court of Protection is often brought in to make sure that those powers are being used in the person's best interests. What runs through the entire Act are sections 1 to 4, and they are all worth reading in full because they set out what I think is the core of the Mental Capacity Act. But I do just want to remind those on this webinar about some of the basics. It's not a replacement for reading them in full, but I'm going to go through them in cursory outline. So section 1 contains a presumption that a person has capacity. It makes clear that any decision in relation to an individual who lacks capacity must be made in that person's best interests, and it must be done in the way that is the least restrictive of that person's rights and freedom of action. Section 2 limits the applicability of the Act's powers to those who are 16 or above, subject to narrow exceptions. And it defines lack of capacity in a way that is often described as containing two stages. The first, diagnostic. Is there an impairment of or a disturbance in the functioning of the mind or brain? The second test is functional. Is the person at the material time unable to make a decision for themselves in relation to the matter as a result of the impairment or disturbance of the mind? Section 3 fleshes out the functional test. And it indicates that one should identify the information relevant to a decision, including the foreseeable consequences of the decision, and then consider whether a person can understand the information relevant to the decision, retain that information, use or weigh the information as part of the decision-making process, or communicate their decision. Now, it's clear that these are alternatives. So if an individual struggles or is unable to understand the information relevant to the decision, they will struggle to show that they have capacity. There are a multitude of cases that illustrate what relevant information may be in respect of different decisions. It's entirely possible for someone to have capacity for some decisions and not for others. Once it's established that someone lacks capacity, that opens the gateway, if you like, to the court potentially making a best interests determination. And section 4 sets out a non-exhaustive checklist of what individuals need to consider when they're making a best interests decision. So you need to consider whether the person will regain capacity, and if so, when. You need to ensure that the person is permitted and encouraged to participate as fully as possible with any act or decision affecting them. Any decisions about life-sustaining treatment must not be motivated by an intention to bring about death. And we're going to touch on this more when I go into the cases, but it's really important to, insofar as ascertainable, identify the person's past and present wishes and feelings, beliefs and values, if they had capacity, and any other factors that they would be likely to consider relevant. Connected to that, one should take into account what those close to the person in question would make in relation to best interests. So that includes seeking the views of anyone named for that purpose by the person who lacks capacity, anyone who holds a lasting power of attorney or is a deputy, and any person engaged in caring for the person or interested in their welfare. So it's about getting all the main decision makers, all the main people involved in the person's life and around the table to ensure that there's input from all of them before deciding what is best interests. So that's all I wanted to say in terms of a very, very quick introduction to the Court of Protection for those who aren't familiar with it. I'm now going to move into looking at some cases which involve geriatricians. So first, UF and ex-county council and others, number 2 from 2014. The background facts to that case, it was all around UF, who was 84 years old and had been diagnosed with suffering from vascular dementia of a moderate level with associated behavioural and psychological symptoms. She resided in a care home and she was deprived of her liberty there under a standard authorisation. She was expressing a strong desire to go home, although as we will see, it was unclear what precisely was meant by home. Her GP reported that she had previously responded aggressively to visits from the GP, and her son reported that she could be verbally aggressive and had on one occasion threatened to stab his sister and set the house on fire. The court was being asked to grapple with 4 issues. First, should F return to her home to live there with a contingency plan of maintaining her current placement for a period of time? So for a trial, essentially. 2, should a direction be given to the Property and Financial Affairs lasting power of attorney holder about releasing equity from US property to pay for her care? 3rd, should the lasting power of attorney for Property and Financial Affairs be replaced by a deputy appointed by the court? And 4, would any care regime at home still represent a deprivation of liberty? The key evidence was the following, and centred really about an evidential dispute as to what UF meant when she said that she wished to return home, and whether she was in fact referring to the care home in which she currently resided or her former home. UF appeared at times not to know where she was. In those cases, when she says return home, it's plausible that she would have meant her earlier home. At other times, though, she indicated that she believed the care home was her home. Dr. Pace, the consultant in community geriatric medicine, appeared to support the court's view that UF viewed the care home as her emotional and physical home. He also noted that if UF were to move home, she would require care from a team with specific mental health skills with specialist support from psychiatric services. So what did the court make of it? First, looking at what UF would have wanted, the court held she would likely have wanted to live and die at home, but it was not clear that she would have wanted others to live at home with her. That was important because she was assessed to require 2 carers around the clock, and there was a real risk that UF would not tolerate being cared for by 2 living carers. The court ultimately ruled that it was in UF's best interests to remain at the care home, and central to that was the court's interpretation of UF's wishes and feelings. It was, however, reinforced by grave doubts that community placement would work in practice, given the significant likelihood of UF not tolerating interventions. The court then dealt with the other 3 issues. After deciding that UF should remain in the care home, it said there needed to be no equity release because no money was needed to pay for care in the community. No party seemed to be seeking a deputy to replace the lasting power of attorney in the end. Whilst the court didn't need to determine it, it did take the view that a return home would likely have involved a deprivation of liberty and therefore needed the court's approval. So what reflections do I think are worth taking away from this case? I think first it shows the complexity of interpreting wishes and feelings when everyday words may have multiple meanings depending on their context. In this case, what is meant by home. Second of all, that the viability of a care package in the community will often be an important factor that parties need to grapple with at an early stage. And third, that even a trial period in this case wasn't approved And part of that, I think, shows the disruption and adverse consequence that can be caused by transitions can often weigh against commencing even a trial move. The second case that I want us to reflect upon is a Court of Appeal case. It's PW in Chelsea and Westminster Hospital NHS Foundation Trust and others from 2018. Now, the background facts to that case at first instance was about how P should spend the last stages of his life. He was a 77-year-old man with end-stage dementia, and the evidence before the court suggested that his mobility had declined such that he was confined largely to his bed. His executive functioning had worsened to the point he required hand feeding, and his oral intake gradually decreased. The cause of that was described as twofold by Dr. Levy, who was a consultant geriatrician giving evidence in that case. And you can see the details of that there. The important thing to factor in is that it was related to his neurodegeneration. At the time of the hearing in first instance between Parker J, it had been agreed that P should return home for the last stage of his life. So all the parties agreed on that. It's an example where you can see the number of issues early on may have involved a dispute between whether end-of-life care in the hospital should be provided or end-of-life care at home. But the issues had narrowed by the time of the hearing, as one often sees in these types of cases. So the dispute was whether P should return home with assisted nutrition and hydration via a nasogastric tube, or should have palliative care and oral comfort being provided instead. Dr. Levy was jointly instructed by the parties. As I said, she was a consultant geriatrician and general physician at Hammersmith Hospital, the chair of the British Geriatric Society Special Interest Group in Ethics and Law, and a member of the British Medical Association's core writing group on canon guidance, currently in preparation. It was her view, shared by the Trust, that it was not in RW's best interests to be discharged home with a nasogastric tube in place. She had took the view and explained to the court that nasogastric tube feeding in the community with adults with dementia is unusual and very rare. And there were risks associated with it, namely nasal trauma, aspiration of feed, dislodgement, and rarely intracranial passage of the tube or oesophageal perforation, all being associated complications. She considered that discharge with a tube would lead to it likely becoming regularly dislodged and then regular returns to hospital being needed in order for its replacement, and that was not considered safe. The judge at first instance was complimentary about her evidence, describing it as nuanced and careful. And you'll see there how it was described by her. So another notable feature of this case after her evidence was that her evidence showed that PW sons were displaying confrontational and aggressive behaviour towards professionals caring for PW. And that shows some of the issues with the disputes that you can have with the professionals in place and the family members when very charged and important decisions of this nature need to be made. The family position was that they had experience of replacing a nasogastric tube, that they themselves would provide P with 24-hour care, and that whilst the nasogastric tube did risk aspiration pneumonia if incorrectly placed, there was also a risk of that if PW was discharged without the nasogastric tube. Key to their evidence was how they explained PW's beliefs as being. And one of the sons described it in the terms set out in the third bullet point. My father is a religious man. He believes in God, angels, and spirits. He is a very spiritual man. He brought us all up throughout childhood to believe in God. My father is not scared of death and has always been ready for it, whenever that time may come. My father does not believe in quitting. His family motto has always been, as long as we do our best, God will take care of the rest, no matter what, until the bitter end. So the court had to weigh this up. And by the time it got to the Court of Appeal, they were considering whether the first instance judge had displayed any error in his judgment. The Court of Appeal upheld his decision. They said he was entitled to conclude that P would wish to die at home. They noted it was not clear what P's view would have been about continued clinically assisted nutrition and hydration, and therefore one should not speculate about what P's views might be. The judge in first instance was very candid about the opportunity to live longer being the benefit of discharge with the nasogastric tube, but found that that would be outweighed by the risk of displacement, the risk of aspiration of food, discomfort, and nasal erosion. And the Court of Appeal saw no issue with that, and the ultimate conclusion that palliation would make RW as comfortable as possible and assure his dignity and comfort. He will pass away with palliation in a dignified way. Interesting further comments that were made in that case by Lady Justice Sharp included whether return home with nasogastric tube was in fact an available option. And the reason for that was that clinicians might refuse to replace or resite the tube if there were repeated hospital admissions, and that in any event it would need to be replaced every 4 to 6 weeks. As those of you who do court of protection often will know, it is only the available options that the court can grapple with. And as such, there was a question whether there was actually a dispute here for the court to determine. Lord Justice Jackson gave this additional narrative to his ruling. He said, as a society, we rightly treat life as precious, but the ultimate purpose of our existence cannot be to live as long as we possibly can, regardless of suffering and indignity. Even for those who see illness and death as a battle, the true mark of a fighter will sometimes be the courage to accept that treatment can no longer bring benefits. As such, the first instance judge's decision for return home without a nasogastric tube was upheld. So I think in terms of the reflections on this case, as I've mentioned, considering carefully what the available options actually are on the ground is important. It's important to have that at an early stage. You need clear evidence of belief, really, because it's difficult to construct that if there haven't been discussion and practicalities of care at an early stage. And I think that was a feature of this case. The children in that case had very strong feelings about what they thought should happen, but the court was limited insofar as it would have inferred belief on PW's part. Third, confrontational dynamics between professional staff and emotional family members can be features of cases like this. And I think it shows the importance of empathy in these cases to make sure that one understands everyone's position and reaches a agreed position wherever that's possible. The third case I want to go through is more recent. It's A, B, and XS from 2021. Now, this case involved a 76-year-old woman residing in Lebanon who was a dual UK and Lebanese citizen. She was diagnosed with Alzheimer's disease in 2013, but continued to have capacity in September 2014 when she travelled to Lebanon, initially moving into a flat close to her brother. Her brother died in April 2016, and XS moved into a care home in Beirut. Now, the evidence before the court was indicative of XS having lost capacity as of April 2016. The applicant sought to effect XS's return to the UK on the basis that that was what she would have wished, and on the basis that the situation in Lebanon risked XS suffering due to shortages of medical supplies. Dr. Karam, an adult and geriatric psychiatrist in Beirut, produced a report where he concluded, amongst other matters, that XS was suffering from advanced stages of dementia, that she had very little reactivity to her environment, and a change of environment and loud noises from the plane may be disturbing. And third, that an improvement in her medical and mental condition was unlikely to result if she returned to the UK. But he did note that if XS could develop an acute complication requiring immediate intervention, that may not be readily available in Lebanon. The court had to grapple with three issues. First, habitual residence and whether the Court of Protection retained jurisdiction. Second of all, whether the High Court could make an order for XS's return to the UK under the inherent jurisdiction. And third, whether it is in XS's best interests to be brought back to the UK. The court ruled that it lacked jurisdiction under the Mental Capacity Act 2005 because XS's habitual residence had moved to Lebanon. The court considered whether it should exercise powers under the inherent jurisdiction, which is described as the great safety net that lies behind all statute law and is capable of filling gaps left by that law. But it considered that using inherent jurisdiction in this case would be wrong because doing so would cut across the statutory scheme, namely the Mental Capacity Act 2005. In any event, when it turned to best interests, the court ruled it was in XS's best interests to remain in Lebanon. And key to the court's reasoning in that regard was Dr. Cram's evidence that bringing her to the UK would be extremely disruptive. It would involve her being cared for by new people in a new place, and it is possible that she might not notice those changes and might find them disturbing and upsetting. But equally, with the best care, she's likely to find the travel of flight physically and possibly emotionally exhausting, particularly so given her very frail state. And that was judged to outweigh the risk of XS potentially not being able to get the medication she needs in Lebanon, which was described as a potential risk. There wasn't much evidence, I don't think, to show that was an immediate risk. So the court noted that XS will be wholly unaware of the fact she had moved to England if she was to return. She will not know either the applicant or any of the people she knew in England, and there was therefore very little tangible emotional benefit to her returning. I think what this case shows in terms of reflections is that a significant move at the end of someone's life may have significant harmful effects. It's very important that applicants identify clear benefits of such a move and are able to evidence it if they want to succeed in their application. So that's all I wanted to say in terms of very basic introduction to the Court of Protection and some cases that involved geriatric evidence. And we'll pass over to Dr. Ben Wildblood now to give an insight from his perspective.
Thank you very much, Jim, for a fantastic presentation, and Matthew for your kind introduction. I'm Ben Wildblood, a consultant geriatrician from the Bristol Royal Infirmary. I'm very happy to be speaking here today. Thank you. So this is what I'm going to talk about. I'm going to discuss some of the decisions that geriatricians commonly make in the best interests of our patients. I'm going to discuss 3 cases which I've changed the initials to anonymise. And then I'm going to reflect on some of the challenges of practicing medicine for the older person in general. So medical treatment. I mean, modern medical treatment is great. We can do some very invasive things. We can put people on life support machines. We can do major open heart and other operations. We can give people chemotherapy to cure cancer. Less invasively, we can do things like give them fluids and oxygen. And then we can give tablets. And at the other end of the spectrum, in terms of invasive medical treatment, we can simply help to to prevent suffering in the form of palliative care. Just taking a step back from the Court of Protection, we have to think that as geriatricians, actually any treatment that we give should be in the patient's best interests. Okay, it would be unethical to give it if it's not. Also, I would argue that it's unethical to withhold treatment that is in a patient's best interests. So not provide it when it can do some good. So actually, a lot of the decisions we have to make on a day-to-day basis are therefore best interest decisions. I want to take a simple case of a patient who was 92, who I'm calling MJ. I work in cardiology for the elderly, and MJ was referred with a severe valvular condition called aortic stenosis. And the question was, should we be considering an invasive procedure called a TAVI? This is a well-known procedure that can very much do good in terms of symptoms and longevity. But this patient was 92, okay, so really was of an advanced age. And that really raises some eyebrows when we're doing invasive treatments. So what do we have to consider here? I mean, you'll have heard of the 4 pillars of medical ethics. Beneficence, this is a proven treatment that is able to prolong people's lives and help with their symptoms. But we have to weigh this against non-maleficence, so the idea of doing harm. Now, most invasive procedures, or all invasive procedures, carry risk. They can cause side effects, and at worst, this is a procedure that actually can worsen someone's life, or indeed, there's a small chance that they might not survive it. And these risks are heightened with people of advanced age. And then slightly perhaps more difficult concept is the justice element to it. When we're doing invasive procedures, they often have a long waiting list. In performing procedures in someone who might not benefit from it, actually there is then the risk that you're delaying treatment of others who would have higher capacity to benefit. So there has to be some kind of balance at a population level as well. Autonomy is of course paramount. I'm going to talk about that a bit later in the talk, but of course that's very important here as well. So what does the Mental Capacity Act say about best interests and age? Well, it's quite clear that you must not make best interest decisions merely on the basis of a person's age. And this is reflected in the Equality Act 2010, that says that a person discriminates against another if, because of a protected characteristic, they treat that person less favourably. However, it does mention that if the protected characteristic is age, then you do not discriminate against a patient if you are using a proportionate means of achieving a legitimate aim. Of course, I should reference the Human Rights Act here, Article 2, the right to life, in saying that just because someone's old, it doesn't mean they shouldn't have life-sustaining treatment. So, if we're not purely going to make these decisions based on age, how are we going to make them? Well, I want to introduce you to the concept of frailty. So frailty is a decreased physiological reserve that leaves a person vulnerable to adverse health outcomes. So I think the important things here are vulnerable and decreased reserve. Now, there's something called the Clinical Frailty Scale, or the Rockwood Score, which is a really useful tool to, if you like, quantify how frail a person is. Now, right over on the left side there, there is people with a score of 1 who are the most fit people for their age. I have to admit, I'm probably not within that group, I'm probably more like a 2. Going all the way down to the right-hand side, where you get people with a frailty score of 8. So these are people who are typically nursed in bed, dependent for all care, and unlikely to survive even a minor illness, such as, for example, influenza. Now, we spoke about adverse health outcomes. What does this mean? Well, there are many. People with frailty often suffer with things like falls. They're more likely to be admitted to hospital. And there's really good evidence that as frailty increases, that the person is less likely to survive for a prolonged amount of time. So they're more likely to die. I think there's no better example of this than the COVID-19 pandemic, which very, very adversely affected frail elderly people as a population. And I saw firsthand some of the devastating effects this pandemic had on that population. Going back to Jim's slides, I think if we take in particular PW, PW was the patient where we had to decide whether or not they should have nasogastric feeding. PW had a frailty score of 8, was very severely frail, nursed in bed, dependent for all care. And I entirely agree that performing invasive, potentially distressing medical treatments in such patients is unlikely to be appropriate, particularly as by definition, they're very likely to be in the last 6 months or so of their life. So, How does this relate to our patient, our 92-year-old? Well, on assessment, actually, this patient was not frail. They lived at home, they were independent for their activities of daily living, and they really wanted to proceed with this procedure. So after a thorough discussion, it was deemed that a TAVI procedure would be feasible. It was possible. The patient was very keen, so it was deemed that the right thing to do was, despite them being 92, to perform this procedure. And it was performed a couple of years ago with an improvement, and my understanding is the patient's still alive. So what does this case highlight? I think it highlights the idea that we shouldn't be making best interest decisions purely on a patient's age and introducing the concept of frailty, which as geriatricians is often holds far more weighting than someone's age when deciding what best interests are. So that's perhaps a relatively straightforward case. This one here was far more difficult. I'm just going to call the patient W. W was 90 and I met her in outpatients. Now, W had a pacemaker and wished to turn this pacemaker off. It was quite clear that the reason behind that was that so she could die. She had a history of depression and had previously explored the idea of dignitas, but had never carried this forward. She had no history of dementia. However, when the pacemaker was inserted back in 2020, it was done so under what we call a consent form 4 for patients who lack capacity at the time when she was acutely unwell. It was clear that she regretted the decision to have this inserted, and we had to think about her capacity. So these were the things to consider. Firstly, is she fully informed? Is she able to understand, retain, weigh and communicate the decision, as we've seen is important in the Mental Capacity Act? And I think importantly in this case is depression preventing a capacity to weigh, and was this part of the reason she wanted to die, because she was really depressed? So on assessment, it was clear that no, she wasn't actively depressed, and a psychiatrist agrees that that was the case. However, I think importantly to this case, we explained that if we were to turn the pacemaker off, it was very likely that she would not die. She would have an underlying heart rhythm that would therefore kick in. However, she was very likely to experience symptoms such as blackouts, heart failure, and shortness of breath. She seemed to understand this and was deemed capacitous at that consultation. However, in view of this information she was provided and the significance of the decision, she was agreed to go home and consider this further. So at this point, I think you've got a relatively ethically challenging situation, although perhaps relatively algorithmically straightforward in terms of capacity and respecting a patient's wishes. However, it got a lot more difficult when at follow-up her capacity was called into question. It's clear that she hadn't retained the previous information she was provided with, and she wasn't clearly able to retain the fact that she was unlikely to die on that given day. It's worth noting this was done by telephone, although she did appear to be able to hear. So therefore, it's got a lot more difficult at this stage. So we took her to a cardiology multidisciplinary team meeting, where there were many decades of experience in the room. And what was notable was that nobody had any experience at all of turning off a pacemaker in a live patient, as this is not normally felt to be compatible with the best interests of a patient. The team agreed it was highly likely to cause symptoms, but really quite unlikely to bring about imminent death. And some went as far as to say, look, I wouldn't be prepared to turn off this pacemaker personally. I'd have to get someone else to do it. So at this point, legal advice was sought. So I think this is important. We've spoken about the Mental Capacity Act stating where determination relates to life-sustaining treatment. It must not, in considering whether treatment is in the best interests of the person concerned, be motivated by a desire to bring about their death. This patient was very open about the fact that they wished to die, but actually we can think about it in another way. What they really wanted was to not continue living a life that they felt wasn't a fulfilling and meaningful life anymore. They're a highly intelligent woman. They like writing and reading, and were hindered by osteoarthritis and vision. They also were quite upfront about the fact that many of their friends had died, and essentially it was more that she did not wish to prolong her life anymore. There's the famous case of R versus Adams and the doctrine of double effect in terms of the idea of preventing suffering and having death as a recognisable side effect to preventing suffering. The Mental Capacity Act, of course, talks about the person's past and present wishes and feelings, and it's clear that this patient did have a kind of lasting wish to die. It's fair to say, apart from at the point where they were happy to have a pacemaker inserted to continue their life. So that was, I think, the anomaly in years of this case. Of course, we've heard that the person is not to be treated as unable to make a decision because they make an unwise decision. And of course, it's worth noting as well that the LPA was very strongly in favour of turning off the pacemaker and was frustrated by the lack of progress here. So how did the case develop? Well, we took the case to ethical panel, which was a team of scholars and doctors who considered the case further. They deemed it was ethical to turn off the pacemaker. It was in keeping with the patient's long-standing wish not to preserve life. They deemed her to be probably capacitous. And I think this is a good concept, that if this was a medication, it would be really quite easy, wouldn't it? If the patient simply had to stop taking a medication that, if you like, was keeping their heart beating properly, it would be much, much more easy. They noted the LPA was in support, and of course the important idea that withdrawal and euthanasia are not the same thing, as most famously represented by the Bland versus Airedale case many decades ago. So what happened? Well, the patient had deteriorated further and was now in a nursing home, and a further capacity assessment deemed her to be capacitous. She was unable to retain the information 5 minutes later, however, due to tiredness. The Mental Capacity Act here is clear that the fact you cannot retain the information for anything more than a short period does not mean you are unable to make that decision. And I think the fact that the patient had continued to make the same decision when presented with the same information was, I think, of paramount importance here. So the pacemaker was turned off. It was turned off at their home. Palliative care support was ready, but actually there was no immediate effect to turning it off. And the patient died several months later of what appeared to be frailty-related illness, rather than through heart-related cardiac causes. So I think all in all, I found this to be a very challenging decision in a patient who had a borderline capacity, but there was a desire to do what was best by them and to allow her autonomy to take effect if this was ethical and legal, which we felt in the end on working it through, it certainly was. This is the kind of case that actually as geriatricians we get an awful lot, similar to this. TL was an 81-year-old inpatient. And it highlights the idea of invasive treatment. We always think of invasive treatment as taking someone to intensive care, putting them on life support machine, doing medically invasive things. But actually we have to think about restrictive treatment here as well. I've got a colleague who recently moved to Canada and was really quite shocked at some of the treatment that is given there in a patient's best interest. Patients are often literally tied to the bed when they're unable to concord with treatment, using restraint devices such as this. And that can be a very distressing treatment for a patient to undergo. At the complete other end of the spectrum, we could simply do what people want, even if they have no insight into any of the risks at all. We could simply respect their autonomy above and beyond anything else at all. TL, it was their third admission in that given year. They'd fallen over lots of times. There were multiple social concerns from the family. They lived in what was described as utter squalor, drunk too much, didn't eat properly, weren't concordant with any of their medications, and the family were, really it's fair to say, at their wits' end. Carers were involved, but were often sent away by the patient. And there was perhaps the idea that at times it was quite unsafe for these carers to attend. This highlights a syndrome really called Diogenes syndrome. Diogenes was a Greek scholar who lived many years ago, apparently in a pot, paying no attention to personal hygiene or nutrition or any other things that we would think are in keeping with someone's well-being. And on calling this person a social worker, they said, yes, we know very well about this person. We have done for years. We've been trying very, very hard to help them in the community for many years. And yes, it's been a real struggle. And this really has been a long-standing pattern. When they've been capacitous to make their own decision, they've repetitively made this decision that this is how they want to live. At this point, however, TL lacked insight into their risks and was non-capacitous to make their own discharge decision. So we had a best interest meeting, and this is what we felt. So I think integral to the case was that we were unlikely to stop this patient from falling. Should we put them in a nursing home, they would continue to fall over. They had a similar lifestyle when capacitous, and therefore it was decided that the patient's deprivation of liberty should be rescinded, and they should indeed return home with carers provided to the best of their ability. However, it's important to minimise the risk as much as you can, so they were placed on a community risk register, and all the help that was available was given to them to try and minimise their risk of harm. And I think this is a really quite a common case that we see similarly day to day in geriatrics. I really, really like this quote. This is from something called Doctor in the House, a sitcom many decades ago. Now you just lie still, old fellow, this has nothing whatever to do with you. And this is obviously medicine practiced very, very badly. And I must stress that even in a patient who is non-capacitous, they should be really at the centre of deciding what's in their best interests. There's an excellent book that I thoroughly recommend called Being Mortal by Gawande, for anyone who's interested. And I really like this quote that nursing home staff like and approve of residents who are fighters and show dignity and self-esteem. However, when these traits interfere with the staff's priorities for them, we start labelling them in a negative way, such as feisty or non-concordant with care. So a positive attribute then becomes a negative one. There's also an excellent book called Escape from Woodland, The Great Escape from Woodland's Nursing Home. And I love this paragraph. It says there are a number of multicoloured pills given to this person, each designed probably to counteract a side effect of one of the others. And when the patient had wondered if it was all worth it for a few extra years in a nursing home, the doctor had merely upped their antidepressants. So again, this is paternalistic medicine at its worst, isn't it? Me doctor, you patient, I know what's best for you, just take these pills and don't worry about it. So, a few reflections from my practice. So, I think first of all, we look at, again, literature and fiction. You might come across House, for example. What you get is a brilliant clinician who I must say is quite often a middle-aged male, which is not is certainly not always the case in practice. Who is supported by a team of brilliant doctors, and they spend a long time looking at the diagnosis. And the diagnosis, making the diagnosis, is really, really key to where we're going for the patient. Once the diagnosis becomes clear, everything is clear from there, and the patient gets better and off they go. Well, that's not how geriatrics is at all. Really, really far from it. This is what geriatrics perhaps looks like. This is the lovely team from Bath. It's multidisciplinary. It involves physiotherapists, occupational therapists, specialist nurses, social workers, hospital discharge team, psychiatrists, and many, many other people. We really, really cannot practice geriatrics on our own as doctors. I reflected recently about my own cognitive biases. And I think as doctors, and probably as lawyers as well, we have to be open and in tune to our own cognitive biases. Personally, if I was an elderly person with frailty, I imagine I would not want very invasive treatment. I want to be treated with simple treatments with a view to being kept comfortable and enjoying my life at home. However, when talking about someone else's best interests, I think we have to be open to the fact that it is someone else's best interests and their priorities we're thinking about, not our own and where our own cognitive biases lie. I've reflected on the idea that actually when taking risks, we are evidence-based to take more risks with our own health than we would be when making decisions in the best interests of others. Geriatrics always involves some risk, and there is often a risk that people will fall over and will come to harm. But what you really, really don't want to be is that geriatrician that sends somebody home and they're admitted 2 days later with this kind of X-ray, which shows a fractured hip. So there will always be some risk, and it's about risk management and appreciation and minimization of that risk rather than trying to remove that risk. It will always be there. What we see is perhaps the iceberg. There are lots and lots of patients in the community who secondary care clinicians probably don't come to contact with. They're managed very well by GPs, by community teams. We probably see, the ice, the visible ice, if you like, as secondary care doctors. And I think probably what makes its way to the Court of Protection and the legal team is really the tip of the iceberg. So I think it's worth bearing in mind everything else that is perhaps occurring in the community, in the hospital and elsewhere. And finally, my final reflection is this. So people with frailty, and in particular elderly people with frailty, by definition, are likely to have a worse prognosis and worse health outcomes than those who are young and healthy. However, this doesn't mean that it's not important, that their health is less important. It really is important. And elderly frail people deserve the best quality care available. They deserve evidence-based care, and they deserve multidisciplinary, well-considered care led by specialist physicians. And I'm a big advocate that this is what we should be providing for our elderly patients.